All right, welcome back. Now, Nigeria's main opposition party, People's Democratic Party, is a party in crisis. Its national convention, scheduled to hold in Port Harcourt, Rivers State on Wednesday, August the 17th, did not hold. It's the second time the convention would be moved. The first convention had to be shifted after a court actually ruled it illegal, even though another court later gave a contrary order. Now, the party then fixed a fresh convention for August the 17th, while negotiation continued to resolve its internal crisis. And after weeks of failed negotiations, the Ahmed McCarthy faction of the party was armed with another court judgment from the Federal High Court in Port Harcourt, empowering it to proceed with the convention, while the Modu Sharif faction had another court order, this time from the Federal High Court in Abuja, declaring the convention illegal. Other stakeholders like INEC and the Nigerian police, who were supposed to take part in the convention, had conflicting judgment on the event, while the Federal High Court in Port Harcourt directed INEC to participate in the convention and the police to ensure security. The Federal High Court in Abuja ordered INEC to stay away from the convention and asked the police not to allow the event to take place. Well, eventually it appears it was the order of the Federal High Court in Abuja that the police obeyed as they barricaded the convention venue on the day of the event and ensured it did not take place. The McCarthy faction of the party later shifted the event, asking the caretaker committee to continue. Now, the situation is painting the Nigerian judiciary in a very bad light, and it's quite ridiculous at that. As at the last count now, 7 courts of coordinate jurisdiction had sat on the matter. The courts on many occasions gave conflicting judgment almost on the same day. In fact, shortly after the convention was cancelled last Wednesday, an FCT High Court nullified the chairmanship of Modu Sharif. Now, it's basically the same case that the Federal High Court Abuja has been dealing with under Justice Okonabang. So what exactly is going on with Nigeria's judiciary? It appears the judiciary is allowing politicians to make a mess with the justice system of this country. Joining me now to talk more about this is G.T. Ogunye, a constitutional and human rights lawyer. Mr. Ogunye, thank you very much for joining us on the program. Let me just get your take. I mean, this is becoming quite embarrassing for the Nigerian judiciary. What's your take?
Well, my take is that most unfortunately, our courts, the Nigerian courts, appear to be turning themselves into the playground for mischievous politicians. And this is very sad. Our courts of law operate in the third arm of government. And so we have 3 arms of government, the legislature, the executive, and the judiciary. So it becomes a sad development when it is not even the arm of government, it's not another arm of government that is manipulating the judiciary, as all can see, or toying with the destiny and integrity of the judiciary, as all can see. But political parties, regardless of whether some of these persons occupy government offices in the executive branch of government in their states or at the federal level, what we're dealing with now are political parties, the leadership of a political party that does not function in any of the 3 arms, manipulating and obviously toying with the integrity of an important arm of government, the third arm of government, the judiciary. So there is no lawyer in Nigeria or any member of the legal community or any serving judicial officer or retired that will be proud of the developments, recent developments in the judiciary, particularly as this development relates to these conflicting decisions and orders being made by courts of coordinate and concurrent jurisdictions in the same federal high court chiefly. The other FCT High Court case, the latest one in this theater of the absurd, stands apart, just this point, stands apart. Before now, we've had these cases chiefly emanating and being litigated at the Federal High Court. And so it's very sad indeed.
In your opinion, what should have been the procedure? Should it have been, I mean, which case, for instance, should have taken precedence over the others? Because as we know, of course, the case before Justice Okon Abang actually came up first. So what should have happened?
These conflicting orders were avoidable. Indeed, they could have been avoided by the judicial authority at the Federal High Court. And I'm talking about Justice Ibrahim Ahuta, the Chief Judge of the Federal High Court. If the judges before whom these cases were being instituted would not do the needful. Now, under Order 49 of the Federal High Court Civil Procedure Rules 2009, a judge before whom an action is commenced can, on his own or at the instance of either party or any of the parties to the action, have the matter referred to the chief judge for reassignment upon coming to a realization that there is a good ground for not taking up this matter or not adjudicating the matter. And no ground can be better than that court realizing that the same cause of action is being litigated before another high court of the same court or another division of the same court. So that judge who is called upon to handle a latter case, who is not expected to bury his head in the sand like an ostrich, who we presume ought to take judicial notice of the fact that there are other cases on that same notorious cause of action, a political action that is so notorious that everybody knows about it. Be you a lawyer or you are not a lawyer, be you a judge or you are not a judge, ought to come to a realization, ought to have taken judicial notice of the fact that that case, that same cause of action, is being previously litigated, and ought to then have that matter referred, so motu, as lawyers say, on his own accord, to the chief judge, who will then reassign same to that judge who was trying that cause of action as a similar or identical matter before, and have the matter consolidated, so that you have this conflicting orders. Now, if that judge failed to do that, the chief judge, also acting under the same Order 49, can call for the file, having taken judicial notice, and indeed administratively realizing that those cases are pending in the court or in several divisions or many divisions of the court, over which he's presiding as a chief judge. So it's part of his administrative functions to then call for those files and have those files reassigned to the same judge that was handling the matter before. So if that had been done, all these cases, be they 7, be they 8, will have been consolidated in the hand of one judge. And so those matters will be consolidated and you then have one decision. And so since the order of a court is not expected to conflict with the orders of that same court, so you won't have this kind of case of conflict. And finally, if the chief judge would not act as a chief judge is expected to act, the NJC proactively and preemptively can indeed issue advisory, because these facts are notorious. So the NJC is not expected, in my view, as I've argued, to sit back and say, we are expecting the petition against one judge for an alleged act of judicial misconduct before we can sanction the judge. Because if the NJC were to wait, and I'm talking about the National Judicial Council, the damage could have been done irreparably to the integrity and the image of the judiciary. And so the judiciary consummatedly could have been turned into a laughing stock of all and sundry. So the NJC, in my view, ought not to wait forever and allow this kind of thing to play out and be consummated before giving advice and then stepping in. But as I've argued, under Order 49 of the Federal High Court Civil Procedure Rules, this could have been avoided. The reason why the Chief Judge is not exercising this power, I cannot hazard a guess. I cannot offer any idea as to why the Chief Judge is refraining from exercising the power that he has to ensure that there is coordination and that there is rationality in the whole process of litigating in the Federal High Court. Because don't forget, the Federal High Court is one court, and these divisions are created for administrative conveniences and for reason of being better able to handle causes of action that may arise from all parts of the country. So essentially it's the same court, and so we are now being treated to the spectacle of having these courts granting conflicting orders, and Nigerians are wondering what is wrong with this Nigerian judiciary anyway. So it's very embarrassing, and as I've said, there is no lawyer in Nigeria that ought to be proud about this development. And what is playing out, sadly, is that Nigerian politicians that we always know as people who would do anything for reason of grabbing political power, whether we're talking about public offices or party positions, who would do anything, who will compromise election petition or election appeal, who attempt to bribe judges, sadly, with the assistance of some senior lawyers or some lawyers who are not so seniors, as we've known, manipulating the judiciary. That's the only explanation you can give, and anybody may doubt this, but when you see a court unusually making disparate orders, as if we dealing with a judiciary that cannot answer to its name. What else can you ascribe that to? Is it because these judges and their chief judge do not know of the order I've made mention of? Those orders are supposed, those rules, the civil procedure rules, are supposed to be used by the courts and lawyers. And indeed, those rules were made by the chief judge of the Federal High Court. So, a chief judge of that court is the custodian of the rules. He is more familiar with the rules, presumably, than even lawyers themselves. So, when you see those orders being there and they are not being utilized to prevent this kind of aberration and auditing, then what will you say is responsible for that? Is it that they don't know these orders anymore, or they are not familiar with their own rules, or they just want this thing to play out and destroy the image of the judiciary? So it's hard to say why we are in this sorry pass. But definitely, this is not the judiciary that Nigerian people will be proud of. And the judiciary, the image of the judiciary is at an all-time low as a result of all these others. As I've said, politicians will do anything. The custodians of these institutions, the operators of these institutions, who have both a professional duty and a moral duty to ensure that their institutions are not destroyed, that are the ones that are expected to keep politicians at bay. Politicians will commit murder. As far as they are concerned, they ain't justify the means. So they will do anything. But we are the ones, the courts are the ones that ought to keep politicians at bay and say, we won't want our cause to be destroyed the way you are destroying your political parties. But unfortunately, that has not been seen right now, and it's a shame.
Okay, but can I ask you one question? Why do you think, for instance, that the judge, the judge in the Federal High Court of Port Harcourt, why do you think the judge just refused to take notice of the case before the judge in the Federal High Court, Abuja? What could be the possible reason?
You know, when a judge throws decorum, judicial decorum, procedure overboard and trumps the due process of law. There are two reasons we can ascribe to that. Either ignorance of the law or corruption. Is either of the two. And so I don't shy away from answering questions from journalists. Is either that judge is ignorant of the law, or that judge knows the law, knows what he's doing, but is decided to be corrupt. So, and you don't even need to be finding out whether money has been given. Corruption is not just about giving money. It's reductionist to think that corruption is synonymous basically with bribery. No, corruption is larger than that. So it's either it's ignorance of the law or corruption. But I'm saying that some judges cannot be ignorant of the law. Indeed, a judge is expected to be so knowledgeable in the law as to be able to discharge his functions knowledgeably and, fairly. A judge who is not knowledgeable of the law is not worth his judgeship. And that's why it is said that, and this is a Latin maxim, ignorantia facti excusat, ignorantia jure non excusat. Meaning, ignorance of the fact, if you don't have information, can be an excuse, but your ignorance of the law is not an excuse. So there is no judge that is expected not to know the law, particularly such basic procedures. So why will a judge set up a situation in which his order will now be in conflict with the order of other courts? In fact, it's bizarre. And so we hope that the NJC will frown at this kind of development and do something that will prevent this kind of auditing, moving forward. I have no doubt in my mind that once something like this occurs, it's either that judge does not know the law or is corrupt. And I've said that corruption is all-encompassing, is broad. So, and it's not just the judge alone. Even the lawyers that are filing these cases, they are encouraging the abuse of court process. Process of court is not only abused when lawyers file a case, it's also abused when other judges of the same powers, realizing and acknowledging and noting that there are cases pending in court, similar causes of action, and yet he sits over a fresh suit litigating the same matter. That's an abuse of court process, meaning that that judge is abusing the process of his own court as well as the process of the other court that is previously sitting on the matter. And so for me, I hope that, and this is a big hope, that the regulatory authorities in the judiciary will do everything to not only sanction judges who err, but lawyers who set this process in motion. Because if a case is not filed, there will be nothing for a judge to adjudicate upon. So for me, as the Yoruba will say, those who aid and abet, that Yoruba called agbekolaja, those kind of agbekolaja, atenitoso, those who set the machinery in motion, those lawyers, those senior lawyers ought to leave, ought to lose their wig and gown, just as those judges have been disciplined. Because if you don't do it, you won't get to the end of this matter. If you think that those judges are the only ones, then you miss the point. For me, in my book, those lawyers are as guilty as those judges. And when we get rid of them in the profession, I think that the profession will be a better place. I envision a situation that if you have 10 senior advocates of Nigeria running foul of professional ethics, they should be shown the door. They should be pushed out of the profession. So you can't just be thinking that young lawyers are the only ones who should be dealt with, while the senior lawyers are being left alone. So if judges are be found guilty of corruption, if Court of Appeal judges have been sent off the bench, if High Court judges have been sent off the bench for corruption and all that, what of those who corrupt them? What of those who offer them those bribes, including lawyers, through whom, look, given the nature of the legal profession, there is hardly a situation in which you have judges being corrupted by lay people without their attorney or some lawyers playing the middle role, the roles of middlemen. So, because to a layman, a judge is like a god. So he looks at the judge with trepidation. He even thinks that he's going to get into trouble if he goes to offer a bribe to the judge. But there will be a lawyer by the side to say that, I know the judge very well, bring the money. So for me, when you send a judge out of the bench, look for 2 or 3 lawyers to also send out of the profession. That is what you have to do. Unless you do that, you won't get to the end of this matter. So for me, you don't need rocket science. I don't need to be a soothsayer to know that when something like this, something as egregious, as catastrophic, as damaging to the image of the judiciary as this happens, we have a fundamental assumption here. It is either ignorance of the law or corruption, and the two of them are bad for the good health of the judiciary and the promotion of the rule of law.
All right, Mr. Ogunye, thank you very much for joining us on the program. Thank you very much for your contributions. We really appreciate it. Well, now, let's just take a lesson to one of the lawyers now, to one of the parties involved in this case. I'm talking about the lawyer to Modu Sharif, narrating what actually happened in Port Harcourt, at the Port Harcourt that's the Federal High Court now in Port Harcourt, when he's actually sent a junior lawyer now to represent them at the case, and what his take is on all this issue.
Some very few people are turning the court into an embarrassment to the entire legal profession and the judiciary. Imagine a situation where you have same subject matter, same party, being entertained by 7 different courts. And even in the same division, turning out different judgments and rulings and overruling each other. There was an embarrassing situation that happened in Port Harcourt today, which I drew the attention of the Honorable CJ through a chief registrar to it. I had to complain to some senior members of the judiciary. There was a matter that was pending at the Federal High Court in Port Harcourt. That matter was filed on the 9th. Ex parte injunction was granted. It was made interlocutory yesterday, and the substantive suit was was adjourned for today. That substantive suit had as defendants IGP, INEC, Director of SS itself, all the defendants reside in Abuja. The matter was held between 9 and 9:45 a.m. this morning. My juniors were there with several papers. The convention they are talking about is about PDP. PDP was not a party to the case, and it's like trying to shave somebody's head behind him. And the processes my boss took to the registry were refused in Port Harcourt until I complained. I had to call the power that be at the Federal High Court, and I said I was going to do a petition. They ordered Mr. Longe back to the registry. Because as at that time, as at 11 a.m., not a single soul could be found at the registry. All of them deserted the place because my juniors were there with the papers. It's very unfortunate. I think the stakeholders should not just be watching. We should all speak out. We should not allow very few people to ruin the Federal High Court. It's very unfortunate.
Every day, every hour, and every minute, news break in Nigeria. Things happen so fast, it's most times difficult to track and comprehend them. But that's what we do right here on DEJI360. 2015, would you want to come back again?
It's like asking Jesus Christ if he knew he was going to die, will you want to come back as the savior of the world again?
We do not just help you track the stories, we break them down, explore all the angles, analyze the issues so that you can fully comprehend the stories and use them to make the right decisions.